against the King.
The board would be assisted if you could address us first, please, on the question as to on the assumption that the defence of duress is available on this trial. How do you reply on those, please?
My Lords, yes, of course. My Lords, my Lady, I appear for the appellant with Mr. Alan Caryn and Ms. Sadette Shalaby, and I learned from Mr. Rowan Pennington Benton and Adam Riley for the respondent. I'll just check as a matter of housekeeping whether you received a small supplementary bundle yesterday.
Yes.
So we seek an order overturning the judgment of the Court of Appeal in this matter. We refuse the appellant's appeal against conviction for conspiracy to commit murder, and also increased the sentence that had been handed down at first instance from 19 years to 35 years. And we asked the court either to allow the appeal on ground A in relation to conviction, alternatively on B, and in either event it may be that the matter will need to be remitted. My Lords, there's a question mark raised in the submissions made by my learned friend as to whether the Court of Appeal had jurisdiction to grant leave to appeal as they did in this case. But Mr. Pennington Benton and I are agreed that the matter doesn't need to be resolved on this appeal, because he agrees that the issues raised are sufficiently important to justify the grant of special leave by the board in any event.
So it's for us to grant special leave?
It's a matter for you in the alternative, but the issues of law are relatively complicated and probably should be considered by the Court of Appeal in the Bahamas first, rather than by your Lordship's board on the first occasion. So I'm not going to be addressing you on that question. My Lords will see we've also withdrawn ground 1, and so we will be taking grounds 2 and 3 in relation to duress, and we'll be taking those together, and then ground 4 is alternative on the sentence. Can I just, in that case, take my Lords to the probably the only necessary issue of the factual background, which needs little introduction. The offence was said to have been committed between the 30th of April 2016 and 1st of May 2016 in Nassau, New Providence. The offence of conspiracy to murder with others, Mr. O'Neill Marshall. And it was alleged that the appellant had entered into an agreement with others to bring the deceased to a pre-arranged location where others shot and killed the deceased. Her co-defendant, Mr. Bain, was charged as an accessory under Section 88 of the Code in attempting to burn the deceased's body, but he was acquitted on a half-time submission. The 3 men with whom she was alleged to have engaged in the conspiracy were arrested and charged, but the charges were subsequently dropped and they didn't face trial. That was the basis on which it had been said in our ground 1 that the appellant couldn't be convicted as the sole conspirator, but we no longer advance that argument. But she is and was the only person who was convicted of this offence. The appellant gave a statement to the police in which she admitted her role, but she claimed that she had been threatened by the 3 other men and had been in fear of her life. In view of my Lord's invitation, may I take you to the caution statement that she gave to the police, which you'll find at page EB268, but for your note, we summarise the relevant parts of her caution statement in our written case at paragraph 61, page 1060. And I will take you to the statement itself. Towards the bottom of the page, at line 21 on page 268, she says, "It started from about December 2015. The first person who approached me was Razor. He asked me, 'Boss lady, do you want to live large? Why don't you show me where your boys stay at?' I then asked who, and he said Yardy. And there's no dispute that Mr. Yardy was Mr. Marshall. he said, I can make $200,000 if I let him know where he lives. I told him I would think about it. I later let O'Neill know what was happening. He and I both removed all of our pictures we had on social media together. Later on, another guy named Carlton approached me. He then asked me what I was dealing with. If I'm ready to snitch out your boy yet, then everything would be safe on my end. I told him I would think about it. The last person approached me about it was a guy named Big Meech. He asked me if I'm ready to deal with Yardy yet, and he also told me I can make $200,000. I told him I would think about it. He told me that he understands that I knew where Yardy is and everything would be okay on my end once I work with him. I just stressed that line there, everything would be okay on my end. There is a clear implicit threat in that sentence. I then told him I would see. We exchanged phone contacts. I no longer thought about it, and I let Yardy know again that they were still looking for him. After I let him know that I wrote down the license plate and sent it to my sister in case anything was to happen to me. So again, it was obvious that the appellant was afraid for her life. I stopped answering Big Meech's calls. We started texting, and he didn't mention Yardy anymore. He mentioned on us throwing a party. I never followed up on him. I figured he just wanted to kill me. Obviously, we place emphasis on that. The following week in April, O'Neill got locked up. I went by Harvey's to check on O'Neill before I knew he was locked up, and a guy by the name of Braden told me he was locked up. It sounded weird to me, so I went to Cable Beach Police Station to make sure he was locked up. When O'Neill got out, he went by Braden, and simply just told him to take his time on the road. About Wednesday or Thursday, I went by Harvey's to get something to smoke. It was too open, so I went in Braden's yard. There I saw Big Meech. He and Braden were sitting down talking. I went over to hail them. They were discussing on ways to line up OJ, aka Yardy. Big Meech was saying this would be the perfect time to light him up. There's no dispute what that meant in this context, was to kill him. He just got released out of jail, so that would be the alibi, people saying they saw O'Neill out because he was supposed to be in Jamaica. Braden then said, yeah, man, that's perfect. That's all I heard. I walked away. Saturday morning, Big Meech called me and told me he needed to see me ASAP, so I directed him by my house, where I felt safe. I never left him in the yard, and he stayed outside by my gate. My mother called me to come to the airport to pick up her office keys. I told her I didn't have a ride, so Big Meech offered to take me. As we were driving, he then threatened me, saying that I'm already in it. I already know what's going on, and this is what I'm going to have to do. So, my lords, those three lines are the most obvious explicit threat. He said, everyone is going to get in problems so they don't go down by themselves. He said that I know too much information and I won't set them up to go down. So lines 10 to 15 in particular. He then later devised a plan telling me that they were going to get a car and drop it off to me. I would pick up Yardy at 10:30 p.m. When I get him, I would drop him in the car at the end of Yorkshire Street and he would send some guys to deal with the situation. I must call him when I get O'Neill. I told him, okay. When 10:30 came, I had second thoughts about it, but I figured I was going to die anyway. Again, we emphasised that line. That's why it took me about 20 to 25 minutes to get out to O'Neill, when in reality he was only about 3 minutes away from me. I finally went in the silver car. Big Meech and the other guy left. I got O'Neill from by Braden, drove through Yorkshire Street and told him I was going to get something to smoke. I pulled the car by the end of the corner by the dead end, got out of the car and ran by my godmother's house. My godfather answered the door. I asked to use the phone, and before I got on the phone, I heard about 7 to 8 gunshots. And there's no dispute that that was when Mr. O'Neill Marshall was killed. Now, my lords, the position is this: the appellant didn't give evidence at trial, so there was never an opportunity for her to have given any further developments of.
We know in the little bit after bit that you read out.
Yes, my lady.
Mr. Meech didn't contact me on Sunday. He did contact me on Monday, asking me if he can see me. I told him no, I was busy. When I'm free, I will contact him so we can meet up. So he gives me something. Was that the $200,000?
Well, my lady, if that's what was being referred to, she never did receive $200,000 because she was arrested and gave evidence to the police in which she admitted the offence, or she admitted her involvement to the extent that that is set out in her caution statement, and she's been in custody ever since.
Could I just ask one question on the facts as set out in her statement?
Yes.
Is it agreed that the events of the evening, dropping the car off and so on, was on the same day as the drive to the airport?
I don't know the answer to that question, but I can take instructions on it. It may be that if my lord were to perhaps let me know what the implications of that might be,
At this stage, all I want, I mean, I'm not asking for instructions to be taken. I just want to know whether, as a matter of the record of the trial, that was assumed, agreed, established.
I don't know the answer to that question.
Okay.
The proximity of the threat
Yes.
to the killing might be.
Yes. Well, it may be, my lord, and I accept that if this matter were to go, if the defence were allowed to be run, there would clearly be a question mark as to whether there were other steps that the appellant could have taken rather than become involved in the offence. And if there were such steps, then I accept that it would be open to a jury to reject the defence. But of course, the point that would be made on her behalf, if this matter were to be heard by a jury properly directed, would be that this was somebody who knew that these were men who were able to take steps to murder people who gave evidence against them. And it would be a relevant consideration, therefore, for the jury when considering the question of proximity to consider whether it would have been reasonable in circumstances where she would have known that going to the police wasn't an option for her, because going to the police would simply make it inevitable, in her view, that sooner or later she herself would receive the same treatment.
And where's the evidence of that? Where's the evidence of her wrestling with the evasive action that she was proposing that she could take?
Well,
where in the statement she says that she, first of all, this starts about December 2015, and the murder takes place on the 30th of April 2016. And the first explicit threat to her life, or implicit threat, is from Carlton. Is that right?
yes, I think what my lord, the point would be this, that this has not been explored. I think that is the.
But it's the appellant's defence.
No, I understand that. Although
that's not the question, is it? The question is whether it should have been put to the jury at the trial as an available defence.
exactly,
And so, what is the test for that? Is it whether on this evidence a reasonable jury could have found that the defence was made out?
well, the test
Or
is.
what is the test?
The test is that which is set out in von Stark, and I'll take my lords to the relevant passage in von Stark, if you'll just bear with me. Yes, so that is. It's EB 2930. Between C and G, which is sets out the circumstances in which the judge should leave a defence to the jury. The function and responsibility of the judge is greater and more onerous than the function and the responsibility of counsel appearing for the prosecution and for the defence in a criminal trial. In particular, counsel for a defendant may choose to present his case to the jury in the way which he considers best serves the interests of his client. The judge is required to put to the jury for their consideration in a fair and balanced manner the respective contentions which have been presented. But his responsibility does not end there. It is his responsibility not only to see that the trial is conducted with all due regard to the principle of fairness, but to place before the jury all the possible conclusions which may be open to them on the evidence which has been presented in the trial, whether or not they have all been canvassed by either of the parties in their submissions. It's the duty of the judge to secure that the overall interests of justice are served in the resolution of the matter, and that the jury is enabled to reach a sound conclusion on the facts in light of a complete understanding of the law applicable to them. If the evidence is wholly incredible, or so tenuous or uncertain that no reasonable jury could reasonably accept it, then of course the judge is entitled to put it aside. The threshold of credibility in this context is, as was recognised in Xavier against the state, a low one, and as was also recognised in that case, it would only cause unnecessary confusion to leave to the jury a possibility which can be seen beyond reasonable doubt to be without substance. But if there is evidence on which a jury could reasonably come to a particular conclusion, then there can be few circumstances, if any, in which the judge has no duty to put the possibility before the jury. So we say that that very low threshold is crossed. And if I go back to, if I may, answer the question put to me by my Lord Stevens as to where is the evidence of her grappling with these issues, firstly, the point to make is that she didn't give evidence. She didn't give evidence on advice, and in the light of the judge giving an indication that there was no defence of duress, and I'll show you the relevant passages. But there is evidence of her grappling with this question throughout that caution statement. It's demonstrated by the fact that she tells the intended victim that she's been approached. It's evident from the fact that she...
what does she tell the victim?
She tells him that, that she's been approached by some bad people who want to kill him.
Whereabouts does she say that?
If you go back to page 268...
that was on previous occasions, obviously,
yes.
than this one.
So, well, she tells him on she tells the victim on 2 occasions that she's been approached.
Well, page 268, line 27, I let O'Neill know what was happening.
Yes, I let O'Neill know what was happening, and then there's a further instance of her telling him... 269,
page line 10.
Yes.
They were still looking for him.
So that's there's that. There's her taking her photographs of herself off social media. It's her on the night in question. She explains at page 270 that she had second thoughts about it, but she said, "I figured I was going to die anyway." Now, my lord, all I need to persuade you of is that it's not so incredible that in these circumstances she was so afraid of these particular men.
But why was she more afraid on the third occasion than she had been when she declined to get involved on the first 2 occasions and in fact told Mr. Marshall that he should be taking evasive action?
Well, my lady, it's very difficult to answer that question. I can see why that question would be properly put to her if she was giving evidence. And the jury could then be invited to draw whatever inferences they want from whatever answer she was to give. At the moment, however, the question is whether the jury should have had the defence put to them at all. Now, it's our case that if there had been a ruling from the judge, if there was a ruling from the judge that duress is available, then the defendant appellant would have received very different advice about giving evidence.
When was this question ruled on by the judge?
Well, it was ruled on at the end of the prosecution, at the end of the defence case.
Right, so she'd already made her... the evidence was already complete at that point.
On advice, and it's clear, my lord, that she was being advised on the basis that there was no defence of duress available.
But if the judge hadn't decided that,
well, let me show you
tell
how.
us what she was or wasn't advised.
Let me show. I mean, obviously, I can't tell you what advice she was actually given.
No.
But
I don't think we can deal with it on that basis. Surely we have to deal with it on the basis that at the end of the case, when the judge came to sum up, if the judge had taken the view that on the law duress was potentially available, should the judge have concluded that a reasonable jury could have found it made out on the facts?
Well, what's interesting...
Now, I think it's your case that it's the burden of proof on the prosecution. That may be relevant, but,
yes.
But that's what we have to consider, isn't it?
It is, my lord, but of course what is to be borne in mind, and I'll show you in a moment where one comes to this, is that the judge in fact directed the jury that duress was not available.
Well, I know, so that we have to assume for present purposes that the judge was wrong about that,
well,
and then decide whether on the law, and then decide whether on the facts the judge ought to have put it to the jury.
Of course, but the reason why I point that out is that it shows that the judge obviously thought that there was sufficient evidence that the jury might have mistakenly taken it into account and acquitted the defendant on that basis, and therefore needed to be directed that they couldn't and shouldn't acquit on that basis. So she obviously was satisfied that there was enough evidence. But let me just take you to the exchanges that happened at the close of evidence. So if I can take you to page 462 of the electronic bundle at the bottom of the page, where the court, Mrs. Justice Bethel said this: "Now, counsel, because she didn't take the box and because you made certain allegations in your addresses, and maybe to Johnson, or it could have been Fox, the question of a defence of duress, counsel for the Crown kept on speaking to duress. Now, on the law as it stands, because I was researching this, I noted that duress is not a defence for murder or abetment to murder, and I would say conspiracy to murder. Would you like to speak to me, with me on that and look at that?" And then Mr. Ducille, counsel for the appellant, said this: "When I spoke of duress, I was not speaking of it as a defence. I spoke of it as the whole question of this agreement, because she didn't murder anyone, so duress could not really arise in relation to murder, as in the case of Dudley and Stevens. That's not what we are talking about." Now, my lords, again, I can't give evidence at all, but I can't tell you what advice was given. But it's plain that at least counsel is approaching this.
Well, counsel took the view that he couldn't, that it wasn't available as a defence.
It wasn't available that it wasn't available as a defence, and that was the view that the judge took. That was the view. Now, if the judge had said to Mr. Ducille, "Now, Mr. Ducille, I know that you've raised the defence of duress. I consider that the defence is available on a defence of conspiracy, and would you like to take instructions from your client in the light of that, because it may be that you would want to advise her as to whether in those circumstances it would be advisable to give evidence."
But this happened after the evidence. This was when the judge was going to sum up.
It's after the evidence is closed, my lady.
Yes.
But at that point, if she had said to him...
That's a hopeless argument, Mr. Bowen. He was making the argument anyway about a sort of duress type of argument on her, as to her state of mind.
Well,
the decision whether to call the client, you can't say, was dependent on this ruling on the judge made after the decision had been taken.
My lord, I'm not saying that the advice that was given not to give evidence was based on what the judge said.
No.
Because plainly that would be unarguable, because the advice had already been given. What I am saying is this: had the judge ruled that the defence of duress was available, then in those circumstances it would have been open to the judge, in fact it would have been incumbent on the judge to have invited counsel for the defence to consider whether they wished to apply to reopen their case so that the defendant could give evidence. My lord is shaking his head, but my lord...
I am shaking my head. I think
that's clearly
it's
something...
all line of speculation.
My lord, it's not...
We have to deal with the trial as it took place, and I guess I would think there were all sorts of reasons why the defendant may not have chosen to give evidence, not least because of the other people who were parties to this conspiracy.
My lord, of course that's right. But what you're confronted by here is a situation...
She chose not to give evidence against.
Where the defence of duress was ruled to be unavailable. It was ruled to be unavailable at a point at which it would have been open to the court, had it ruled another way, to have given the appellant the opportunity to reopen the question of whether she wished to give evidence. But even if...
I didn't quite follow you in the sense of I thought your case was that the evidence in the statement was sufficient to go before the jury on its own.
Yes.
It didn't require her to give any evidence at all.
It doesn't.
And my point was, where is the evidence? Well, if you turn to page 1084, item number 6 in the respondent's list of the various items which have to be addressed in relation to duress, where is the evidence of the defendant taking evasive action, apart from wholly, very thin evidence as to what she did in relation to the first 2 occasions she met Razors and Carlton, and then totally no evidence at all after she met Big Meech on the morning, potentially of the day on which he was the murder was committed, or potentially at some other distance removed from that day.
But the question is not what evasive evidence could she have taken, but the question is whether there was any evidence it was reasonable for her to take, and that would have been a matter for the Crown to establish. They would, if there is no evidence, if there's no evasive action that it's reasonable for a person to take, and the Crown are unable to satisfy the jury to the criminal standard that there's no such action, then the defence is available. It's not a question of her having to prove.
But then in every single case in which a gangster threatens somebody, you're going to be saying, well, there's nothing that can be done. I've just got to go follow through with the threat. I can't go to the police. I can't tell the person who's threatened.
We're not talking here about that the jury would necessarily accept it. We're talking about
the evidence available to go before the jury in relation to evasive action. Right. And at the moment, I want to be persuaded.
Yes, my Lord. Well, the starting point, as my Lord Legate pointed out, is it would be the Crown to prove that there was evasive action that should have been taken and that she failed to take.
Let's assume that that is going to the police.
And then it's a matter for the jury to consider whether, in the circumstances of this case, it would have been that was reasonable. That would have been a reasonable step for her to take, in the context of a conspiracy to murder, or a murder, which was said to have been against somebody who was being murdered because they might give evidence against those who were responsible. Now, in those circumstances, it would be open to a jury to conclude. I'm not saying they would conclude, but it would be open to a jury to conclude. It's not completely far-fetched that it was not reasonable in the circumstances for her to have taken that evasive action, because she would have concluded that she would end up in exactly the same position as. And
how about warning O'Neill in some way? Not necessarily when she picks him up, but before that. So it might be better if you go on holiday.
Yes. My Lord, if she's told him that there are people who are trying to kill him, then she's taken some evasive action.
I mean, the evasive action doesn't have to be going to the police or telling him. It could just be not going to collect the car.
Well, my Lord...
It doesn't actually require positive evasion here. It just required not directly participating in the plot.
But she does address that in her statement, because she says, I had second thoughts about it, but figured that I was going to die anyway. That's page 270 at line 23. When 10:30 came, I had second thoughts about it, but I figured I was going to die anyway. So that's not evasive action that it was the Crown have proved that she should have taken, because she's already addressed that she was afraid that she would die if she didn't. So the steps that were available to her: one, to warn the victim, she took; two, go to the police. Well, this is an offence that it involved the murder of a witness, and therefore she would have had a reasonable fear that if she was going to give evidence against him or go to the police, she would die anyway. Thirdly, not getting involved at all. Well, that's not exactly evasive action. That's just not taking the steps that you've agreed to take.
Yeah. So another way of looking at it is did the threats cause the action?
Yes, and the answer to that is clear in lines 23 and 24 of page 270. I had second thoughts, but I figured I was going to die anyway. My Lords, the point is there enough evidence that this, had the judge reached the correct conclusion on the law, she should have then left the defence to the jury. The answer to that is yes, because it's a very low threshold, see von Stark. If this matter were to then go back to the for a retrial, it's our case that in those circumstances she would receive very different advice, because all the matters that my learned friend addresses in his skeleton argument and that my Lord Stevens has just taken me to would be matters that she would be well advised to then give evidence to address in her evidence, so that there's more positive evidence than is contained in her caution statement. But that's not the test that I have to satisfy you of. I just have to satisfy you on the assumption that my lords have put to me that the defence is available, that the von Stark test is satisfied. And that is in the context, as I've already submitted, that it's for the Crown to prove each of the elements, to disprove each of the elements that make up the defence. So, my Lord, that's my case. What should be done or what should have been done on the assumption that the defence is available. And that's
I think you're almost compelled, aren't you, to say that the judge should have permitted your client to be called again, because during the course of the running of the trial, the judge can't interfere. He's got to allow the parties to present their case. So the issue as to whether or not there was a evasive action isn't going to be addressed at all by either of the parties. Neither of them are addressing duress. The part that you've taken us to, where there is a discussion with counsel, that takes place after closing speeches by counsel, isn't that right?
Yes, that's during the sweeping up.
Just before the summing up, after closing speeches, right? And
or is it before closing speeches? That in a normal time, but
I think
it should have been.
It should have been before closing speeches. It's before closing speeches, but I'll check that.
It should have been before, and it was after. Yeah. Okay.
Thank you. I'm very grateful to my lord.
And so, at that stage, there's been absolutely no submissions about evidence about the evasive action that could or couldn't have been taken.
Well, the only evidence
and the judge would then have to, if he was just going to leave it on the basis of the statement that your client had made, he'd have to speculate about all sorts of things.
Well, no, the jury would be entitled to draw inferences. It's not a question of speculation. They had evidence because the caution statement was read out. So there is positive evidence, and the inference that it would be open to the jury to reach in relation to evasive action was that in the circumstances of this case, where the victim was said to have been targeted because he was going to give evidence against the co-conspirators, it was not, this was not a case where the evasive action of going to the police should have been taken by the appellant, because it would have led to exactly the same consequences that she was afraid of. It's not like she could avoid those consequences.
Well, it's enough for you to say that the jury could have concluded that was a possibility which hadn't been excluded by the evidence.
It had not been proved beyond reasonable doubt. The
prosecution had to prove their case.
Exactly. So, my lord, it's not a question of speculation. It's a question of inference from the evidence that was available to them. And as I've said, for the purposes of this proceeding, where I'm trying to persuade my lords to overturn the conviction, I only have to satisfy you that evidence reached the threshold of set out in von Stark is not for my lords to.
I think you're trying to persuade me as well.
And my lady, not to step into the. I beg your pardon, my lady, not to step into the shoes of the jury. As long as it is not fanciful that a jury could have concluded in these circumstances that the defence would have been available.
And the reason why the judge raises this before her summing up was because in their closing speeches, the Crown kept, she said, harping on, duress, duress.
Yes, my lady.
And she asks Mr. Lancey, well, why were you harping on about this? Is duress going to be an issue in this case? And she asks for submissions on that, to which Mr. DeSille says, no, we're not raising duress, and Crown says, oh, I just mentioned it because he was mentioning it. So what was actually said in the closing submissions about duress that set this hair running?
My lady, I have to accept that duress was not squarely raised by the defence during the trial. It was not raised as a defence.
What was the defence?
Squarely.
I mean, if it wasn't duress...
What was raised was that there had not been either the necessary agreement or the necessary mens rea. It was a bit difficult to establish exactly what. For the purposes of the offence of conspiracy, by reason of the coercion duress that was brought to bear. So coercion was relied upon factually, but the defence of duress was not. And whether that is because an assumption was made by prosecution, by counsel for the defence, that it wasn't available, which was the assumption that the judge was operating under, in my respectful submission...
Well, the judge seems to have been a bit doubtful about it in relation to conspiracy, but counsel for the defence said wasn't taking the point. So.
And my lords, this won't be the first time you've been in this situation where a point that's being raised before the board, it was not raised
But
squarely.
The jury must have concluded that they were satisfied beyond reasonable doubt that coercion did not somehow negate her agreement to the conspiracy, if that was the defence that was being put to them.
Well, my lady, that would be a fair point to put to me if it weren't for the fact that the judge specifically directed them that duress was not available as a defence. So can I ask you to turn to page 511? This is in the judge's summing up, starting at line 13, and this is the very direction with which we take issue.
Which page again?
It's page 511 of the electronic bundle, my lady. Line 14. Now, there's one other thing I would like to touch on. You would have heard the word duress being mentioned by the defence and the Crown. Duress is, in certain circumstances, is a defence. It's an excuse, a justification as a defence. No one commits an offence unless he or she acts unlawfully. Therefore, it goes without saying that if he or she has a defence, that it was justified in doing what he was doing, then you would not have acted unlawfully. So if, in other words, an accused has said that they felt threatened, that they were forced, they felt they would be killed to commit a crime, they may use the defence of justification to commit that crime. However, Mr. Foreman and members of the jury, the defence of duress is not available to the offence with which the defendant has been charged. It is not available to murder or to any secondary person who aids, abets, conspires to commit murder. So even though you might have heard that word being uttered, duress is a defence to all crimes you would have had to consider normally, except murder, attempted murder, where the charge is the principal or as an abettor, an accomplice, a counsel or a procurer. The law behind that is that where a person is stating to you that they were threatened to commit murder, there is no excuse not to go and inform someone of not to seek help. Duress is not an excuse for taking someone's life, or abetting to take someone else's life, or conspiring with another to take someone else's life. It's not an excuse that could be used. So, my lady, you can't draw any inference from the jury's verdict that they had rejected the defence of duress. And indeed, that's one of the points we make in relation to sentence, because this wasn't dealt with properly at the sentencing stage either. So
that would negate your secondary argument.
I beg your pardon, my lord.
That would negate that direction would negate your secondary argument that coercion in some form negated agreement.
Well,
that effectively was the argument being made, was it?
That effectively was the argument, but I mean...
It's a hopeless argument because an agreement that you've been pressured by threats into making is still an agreement. I mean, that's the whole point about duress.
I won't spend very long in that case directing you in relation to that particular aspect of the argument. But at the moment, I'm working on the assumption you've asked me to work on, that yes, the defence is available, that in those circumstances, what should the judge have done? Answer, there was sufficient evidence for the defence to go before the jury applying the von Stark test, including in relation to the taking of evasive action, bearing in mind the context in which the offence was committed, namely the murder of a witness, so it could not be said beyond reasonable doubt that the only reasonable action that she could have taken was to have gone to the police. And in those circumstances, the judge should have left the defence to the jury. Now, of course, I accept that the defence would have been much more likely to succeed if she had then gone on and given evidence, but we can't reconstruct events to create that set of circumstances, and it's not for this court to seek to speculate as to what the jury would have done had the defence gone to them on the basis only of the caution statement. You only need to apply your minds, if I may put it that way, to the test in Von Stark. Now, my lords, I've addressed you on that point. I'm assuming that you still wish to hear from me, however, on the question of whether the defence is available, unless you indicate otherwise.
Do you want to hear the full argument on this point first? From the other side, I think
We should hear full argument
or not.
Yeah, that's right. Yeah, okay.
We'll rise for a few minutes and take stock. We're very grateful to you. Thank you. Benton would like to hear you on this first point.
Yes, thank you very much, my lady. So, my lords, the starting position for this is to just respectfully remind ourselves, if I can be so bold, as to the requirements of duress and what needs to be put in issue. So that, we can turn to the case of Hassan, 2752. So the facts in very brief, my lord, are that Hassan worked as a driver for a woman who was running an escort agency. Count one, this is a burglary case, so count one of the burglary is that he went to one of the client's houses, robbed him of £4,000 in cash from a safe, so that's count one. Count two was that he went back to the house on the 23rd of January 2000. It is relevant looking at the facts, though. There's a point to me doing this. Forced his way in with a knife and tried to rob the same safe he'd robbed on the previous occasion, but there was no money. And what he said was that him and his family were threatened to go back on the second occasion and attempt the burglary, by a man called Sullivan, and that Sullivan sent a man along with the defendant to the house, and that man had a gun. He was convicted on the second count. Now, duress was put to the jury, because obviously this wasn't a murder case, it was a case in which it wouldn't be put. But he appealed, complaining about the nature of the directions that were put. And the important question for present purposes is question 3, the third certified question, which is on 2772. The third question, could the defendant have avoided acting as he did without harm coming to his family? That was the standard direction at the time. And then the judge goes on to refer to some of the evidence, and at the end, at the bottom there, on 2772, if you are sure that he could have avoided acting as he did without harm coming to his family, the defence fails and he is guilty. And at the bottom of page 2773, paragraph 16, the Crown seeks to establish that the judge's directions on the third and fourth questions involve no direction. Fine. But what Lord Bingham does go on to do is to focus on this particular issue of imminence. Over the page, we'll just ask your Lordships to read paragraphs 17 and 18. And particularly 18, where duress does not ordinarily operate to negative any legal ingredient in the crime. I only say that because we're here in the judgment anyway. But then paragraph 20, where the evidence in the proceedings is sufficient to raise an issue of duress, the burden is on the prosecution to establish to the criminal standard that the defendant did not commit the crime. But there is, in other words, an initial evidential burden, and I accept, of course, we accept, of course, that it is some evidence. It doesn't have to be good evidence or strong evidence, but it has to be some evidence on which a rational jury, properly directed, could convict. What we respectfully say is there has to be some evidence on each element.
Was that direction or the question approved? I mean, was that the correct direction to the jury, the question 3 you showed us?
Well, yes, it wasn't a misdirection, but what Lord Bingham does is give some further guidance as to what should be added to it effectively in cases. It should be made clear to the jury some additional points about imminence that I'll come to shortly. So it wasn't wrong, but I think the basic message is not full enough. Mm-hmm. And His Lordship at paragraph 20, 2774, talks about the difficulties of disproving duress once it's put in issue. Depends on assertions which are peculiarly difficult for the prosecution to investigate or disprove, particularly, of course, if it's raised at trial for the first time. You now have defence statements, but it's still a reasonable point. And therefore, at paragraph 21, His Lordship says, I find it unsurprising that the law in this area and other jurisdictions should have been developed so as to confine the defence of duress within narrowly defined limits. And then His Lordship goes on to identify what he refers to as the most important limitations. And what we respectfully submit is that these, or at least some of these limitations, delineate what a defendant must show in order to put the defence in issue at all. So, in other words, point 1, duress does not afford a defence to charge of murder, fine. Point 2, to found a plea of duress, the threat relied on must be to cause death or serious injury. In my respectful submission, the first thing any defendant who wants to put the defence in play, he must, or she must, put forward at least some evidence of a threat to kill or cause serious injury. Point 3, the threat must be directed against the defendant or his immediate family. And then point 5 on the next page, the defence of duress is available, i.e. you can run it only where the criminal conduct has been directly caused by the threats. And then 6, the defendant may excuse his conduct on grounds of duress only if there was no evasive action he could reasonably have been expected to take. So what we say is, it's actually incumbent upon a defendant to put forward some evidence that this was an imminent threat that they could not avoid. And if they put forward some evidence of that, then it flips to the prosecution. It doesn't start out on the prosecution being required to prove that evasive action could be taken. You don't get to that point until you've put something in. And what the defendant what Mr. Hassan said is, well, I didn't have a chance because the guy was there with a gun, he came to the house with me, he was there the whole time, I didn't have a chance to go off and do something. Fine. Then it flips to the prosecution to say, oh, well, there was this window of opportunity. My lady, my lords, then I would just highlight the passage, 2776 electronic bundle at G. The features of duress to which I have referred above incline me, where policy choices are to be made, towards tightening rather than relaxing the conditions to be met before duress may be successfully relied upon. And then 277, some support for that position is derived from a judgment of Dixon J in another case. And then paragraph 24, at the bottom of the page on 277, answers my Lord Legate's point. Well, the Court of Appeal held that the judge had misdirected the jury on question 3. Not that the question was wrong, but there was no suggestion the defendant could have taken evasive action. This may or may not be so on the facts. And this suggested misdirection does not feature in the question on duress certified for the opinion of the House. It is true, as the Court of Appeal recognised, that there may be an area of overlap between questions 2 and 3. Question 2 is the certified question about the objective nature of the test, whether a reasonable person would have acted in response to the threat. A reasonable person of a defendant's age and background would not have been forced and driven to act as the defendant did if there was any evasive action reasonably open to him to take in order to avoid committing the crime. And this is the key point. It's about avoiding committing the crime. It's not avoiding harm.
Well, I'm not sure, because what the judge said is that the prosecution have to show that there is evasive action that the defendant could have taken without him or his family coming to harm.
Yes, at that time. So in other words, you had to commit the crime because if you didn't, then and there, harm would come to you.
The harm doesn't have to come then and there, though, does it?
Yes.
That's not an ingredient.
I think that is the correct way of immediately or as near as immediately, yes. So in other words, if you can avoid committing the crime, and I make good that proposition by what follows on the next page, so 2779. Yes, so 2778, before we get there, I'm jumping the gun, before we get there, 2778 at paragraph 26, Lord Bingham refers to recent English authorities that have tended to lay stress on the requirement the defendant should not have been able to avoid compliance. But then there's the point made by Lord Morris in the Lynch case, that duress must never be allowed to be the easy answer of those who can devise no other explanation of their conduct, to avoid the dominance of threats of some gangster tyrant. And then this is the essence of the point, Lord Simon opinion in the same case. A person honestly and reasonably believing that a loaded pistol is at the back of their neck, at his back, which will in all probability be used if he disobeys. I'll come back to that point in a moment, because that's really the essence, I respectfully submit, of what Lord Bingham is saying. He's saying that this is a gun to a head, either actually or metaphorically, that forces you to do the crime. And then his lordship suggests on the next page at paragraph 27 that the case of Hudson, Court of Appeal decision of Hudson, had the unfortunate effect of weakening the requirement that execution of a threat must be reasonably believed to be imminent and immediate if it is to support a plea of duress. And then His Lordship goes through the facts of that case. Can I just invite Your Lordships to read?
But is that because if the threat is not imminent, there is more opportunity to inform the police or warn the threatened person or something?
The underlying rationale, I think my lady is asking me, is could you take evasive action? But what doesn't appear to be part of the inquiry is the effectiveness. In other words, if you can wriggle out of the clutches of someone who's got a gun to your head to avoid committing the crime, then there isn't a case of duress just because you think they might get you later. Even if you're right that they might get you later. Because it's gun to the head stuff. That's the point. And my lady, I realise that does place the threshold very high. But actually it's a point that's made good in these passages, because the case that's being criticised by Lord Bingham is the case of Hudson. And the basis for the criticism, this is two young women, girls, who were called as witnesses to an assault case. And they gave false evidence saying that it wasn't the accused, even though they knew it was the accused. And then those two girls were later tried for perjury. And the judge in the perjury trial directed the jury that this was not a case of duress. It couldn't be a case of duress because the threat couldn't be carried out there and then in court. The Court of Appeal overturned that judgment. And this is, we can pick this up on paragraph 27 at letter D. Sorry, letter C. The trial judge ruled that the threats were not sufficiently present and immediate to support the defence of duress. But this was held by the Court of Appeal to have erred, since although the threats could not be executed in the courtroom, they could be carried out in the streets of Salford that same night. And what Lord Bingham says on the same page in between letters F and G, I can understand that the Court of Appeal in Hudson had sympathy with the predicament of the young appellants, but I cannot, consistently with principle, accept that a witness testifying in a Crown Court at Manchester has no opportunity to avoid complying with the threat, incapable of execution there and then. And he draws an analogy with the necessity cases and the lack of imminence and lack of degree of directness and immediacy. And then we come to paragraph 28, where His Lordship squares this effectively with the existing direction. And I accept it's not perfect, because as my Lady Rose quite rightly points out, the specimen direction says, you know, you can avoid harm to me or my family. The way Lord Bingham squares that, he says, well, it should, however, be made clear to juries. It's not open to criticism, he says, first of all, the specimen direction, but he says it should, however, be made clear to juries that if the retribution threatened against the defendant or his family or a person for whom he feels responsible is not such as he reasonably expects to follow immediately or almost immediately on his failure to comply, there may be little, if any, room for doubt that he could have taken evasive action, whether by going to the police or in some other way, to avoid committing the crime with which he's charged. That's the point. It's not duress to say, somebody said they'd kill me later on if I don't do something now. So I say the questions for the board are, did the appellant adduce any evidence on which a jury could reasonably rely to establish a threat of harm that would be imminently carried out then and there, preventing her from avoiding committing the crime? And the answer to that is no.
So even if the jury had come to the conclusion, for example, that there was a genuine threat to Miss Moss's life at some point in the future, she could have gone to the police, but experience shows the police would not in fact be able to protect her any more than they were able to protect Mr. Marshall in the event. But you would say that that would still not be a defence because the threat is not going to be carried out immediately.
If the threat of, yes, I would say its primary position is if the threat of harm is not one that can be carried out immediately, and therefore prevents you from avoiding the crime, then it's not a case of duress at all.
So you say if the person's thought process were, well, I have to do this because sooner or later they'll come and get me, that's not good enough.
That's not duress. That's not duress at all.
It might mitigate sentence.
Yes.
Yes.
And you might, if you're lucky, get past a jury. It may be wrong in law, but you may well survive on the jury submission on a common sense point. Well, this person didn't really agree, did they? In other words, the way the case was put in this trial was, well, ladies and gentlemen of the jury, he didn't really agree, she didn't really agree because she was under all this pressure. And you might, in other words, persuade a jury that there wasn't an agreement. You might do. But yes.
But was that defence put to the jury by the judge?
Well, not really, because it's not actually a defence in law. Because, for the reasons identified earlier, it's technically speaking, well, not technically speaking, the law is, even if you agree under duress, you still agree. And even if you intend to do something under duress, you still intend to do it. So duress doesn't negative any of the elements of the crime. But it doesn't mean you couldn't get a defendant off in practice by running a case before the jury. Well, come on, ladies and gentlemen of the jury, she didn't really agree. I mean, it happens. Whether it's a sound result.
We're not concerned with what the jury, that sort of point.
Sorry?
Yeah. We're not concerned with that kind of question here.
No, I'm just trying to establish the context here, because it's plain in this case that the Appellant's counsel, rightly in my submission, knew that duress couldn't succeed. And therefore, the next best case was the case that he run, which was, well, there's no agreement, was there? But anyway, the point on the authorities, my primary position is, unless there is an imminent threat that can be carried out that leads you to being unable to avoid the crime, then that's that. However, I do accept that there is this slight inconsistency that my Lady Rose points out, that, well, how do you square that with the fact that you must be looking at efficacy to some point, to some extent, because you're looking at avoiding harm to you or your family, so you can't completely ignore efficacy. So I'm trying to think of a case. As a secondary position, I would say, well, look, if I'm wrong on my primary case, that actually an imminent threat or nothing.
The most common situation of harm to family is the family is held hostage.
Exactly.
And
but that's imminent. They're there.
yeah.
But the alternative case arises on Lord Bingham's paragraph 24, where he 28, where he effectively tries to square what he's saying about imminence with the specimen direction. And his lordship says there may be little, if any, room for doubt that he could have taken evasive action to avoid committing the crime. I mean, you could say, well, take a evasive action, what evasive action, and therefore you could get into these questions about, well, what evasive action was available. So, but even if that's right, in other words, even if the question is, well, some harm might be inflicted later that I couldn't avoid, it was still for the appellant to adduce some evidence on which a jury could reasonably rely to establish why she says she couldn't have taken evasive action. And there's no evidence at all. I understand, appreciate the victim that was killed was obviously somebody who was in witness protection. But having said that, if the inference must be in this case on these facts, that even in a small place like the Bahamas, if the victim wasn't lured out of witness protection by the appellant, the gang couldn't get him. Hence the reason why they're going to all this trouble. So the starting position on the evidence, well, look, I mean, there is a police force, there is a witness protection scheme. She hasn't given any evidence on which a jury rationally, acting rationally and properly directed, could say, oh yes, well, that meets point 6 of Lord Bingham's. I don't know if I need to go and apply that to the caution statement because your lordships have already seen it, but it might assist to do that. It's at 268 bundle. Line 17. Okay, good, thank you. Well, my lady, my lord, you've read these passages. I don't need to go through them. I think I can sort of skip, really, to 269, line 11. After I let him, the deceased, know, I wrote down the licence plate and sent it to my sister in case anything was to happen to me. Then she says she is invited to a party. She said, I never followed up on him. I figured he just wanted to kill me, i.e. at the party. And then it's a whole week, or at least it's the following week, before there's any further action. She doesn't, and then on line 25, Wednesday or Thursday, I went by Harvey's, which is, I think, is a bar. I think, it could be a person, it was mentioned at Harvey's, but anyway, get something to smoke. It's too late, too open, so I went in Braden's yard, saw Big Meech. So she went over to them, voluntarily, presumably. They were discussing on ways, so at this point, she knows there's a plan to kill the deceased. She knows they have already asked her to participate in it and are continuing on her case to threaten, to coerce her to do so. There's no suggestion at that point that she was somehow unable to do anything about it or that the threat is imminent. I appreciate there's not been an agreement yet. It's not the right time to test it. We then get to Saturday morning. She's threatened on the drive to the airport. She says, what I am going to have to do, inferentially that must mean what they've been asking her to do, namely to bring out the deceased.
And just going back to Lady Rose's question.
Yes.
It was Saturday morning, the 30th of April. Because there's a gap between the morning and 10:30 in the evening.
Yes.
But is it a gap on the same day?
I believe that, I don't know.
Yeah.
It looks as though it was, in the absence of anything to say otherwise.
Yeah.
The conspiracy is said to have taken place on the 30th and the 1st. And on the 1st, all that happens on the 1st is, she says, Big Meech called me and I said, I'm busy.
Yeah.
So it's not clear
She
to...
was killed in the early hours of the morning of the 1st or late at night.
Late at night or early morning.
So if
Friday, his body
the
was found at
date
12.
given for the conspiracy is the 30th of April to the 1st
Exactly,
of May,
so-
then that must cover the date on which the agreement is alleged to have taken place.
So inferentially from the particulars of the offence, which is over 2 days, it would seem to be Saturday the 30th and then Sunday the 1st of May, because nothing happens on the Friday.
Do we have the indictment in the...
Yes, it's at page 11.
Well, the 30th of April was a Saturday.
That's right, and then on Sunday the 1st of May. So because nothing happened on the Friday, it seems to me it must be...
Saturday morning is the airport trip, and Saturday night is the
Yes.
is the killing.
The agreement is at lines 16 to 21 on page 270, unless you include turning up as part of the agreement, going ahead with it as part of the agreement, which you could, of course. But it's lines 16 to 22, and what she says is there's the morning airport trip, and then later, we don't know how much later, he devised a plan, and nor do we know the means by which he communicated that plan to her. But there's no suggestion there that he's got, at that stage, a knife or a gun to her head, as it were, metaphorically or actually. And she said, I told him okay. 10:30 p.m. came. I had second thoughts. Well, okay, didn't do anything about them. But I figured I was going to die anyway. We say, whichever way it's put, either my primary case or on the secondary case, there is just nothing there on which a jury, even if the prosecution asked no questions and did nothing, there's just no basis upon which a jury could actually find that she may have acted under duress. It just wasn't put in play. There's no evidence, to use the words of Lord Bingham, that this was a threat that was going to be carried out then and there, unless she complied, and that threat then and there prevented her from, meant that she had to agree. Where's that page? That's after the agreement, yes. Okay, it's just being pointed out to me at lines 27 to 28 on page 270. She went in the car, the silver car, Big Meech and the other guy left. There's lots of gaps here, that's the point being made. There are lots of gaps. She's got a car, she doesn't have to go and pick them up and so on and so forth. But I think the point for conspiracy, the point that would be said against me there is, well, hang on a second, the conspiracy liability lies in the agreement. And the agreement is at 16 to 22. There's no evidence that that agreement was reached. Acting under duress in the terms explained by Lord Bingham.
I told him okay.
You say Lord Bingham uses the phrase then and there. Could you just take me back to
Yes.
R against Z?
Yes.
Is it page 2779? Whereabouts does he use the words then and there, as opposed to follow immediately or almost immediately?
I have got then and there. Bear with me just a moment. Two 779. 27. Hudson, yes, it's
Yeah.
then and there, yes. But I think that's also borrowed from the earlier.
Yeah. Okay.
Where did we say it? 2779.
Letter G.
Thank you. Yes.
But the message here is, if one considers the facts in Hudson, the message here is you don't speculate and get into you don't have to get into a discussion about effectiveness and what might happen later and all that sort of stuff. Unless someone's got a gun to the head, do this now. It's just not addressed. That's the message I respectfully say. Close from all of this.
And that's a policy choice.
Yes, because otherwise, and it's a policy choice driven, at least in part, by the problem that once the defence is in play, it's pretty difficult for the prosecution to do much about it. So in other words, in the normal cases of defences, of course, the defence usually negatives some part of the offence. So in other words, the usual burden, the usual criminal burden is on the prosecution to prove all elements of the offence. So if somebody comes along and says, well, look, my defence is I didn't, intend to do this or something like that, then it makes sense that the prosecution's got a clean run at disproving their defence, because it's part and parcel of proving the elements of the offence. But duress is slightly different. It has to rely to some extent on a defendant putting forward a positive case.
In the policy cases also, you don't have criminal activity carried out by proxy at the command of terrorists or gangsters.
Certainly. And therefore it's constrained to very narrow limits. And in terms, finally, on the point about the evidence that was led, and maybe it would be different if the appellant thought that duress could be run in a conspiracy case. The case that was run was based on coercion. So the case that was run was, there's no intention, there's no agreement, because she didn't really want to do this. She was being pressured. So one can respectfully infer that the defence counsel would already have been running his best case on coercion. Because if his case was, she was coerced into this and therefore she didn't really agree, he has to run his best case on that. The idea that he would have suddenly called evidence if he'd known that duress was available. A, it's speculative, but B...
No, but in answer to the question I put to Mr. Bowen, that, well, can we infer from the verdict that they rejected even that case on coercion? His answer was no, because the direction that duress is not available effectively knocked out that case, and it hadn't really been put in the summing up to the jury at all. Do you accept that?
I think I do. Can I just be a bit clear about what I'm accepting? Just a clarification on exactly what I'm accepting. I accept that the judge said duress is not available, and I also accept that the judge didn't really put the appellant's alternative case. There was no agreement.
She didn't.
No, because she rightly thought, well, in law, it's just not relevant. But you still have the closing speech, of course, and it's still therefore open to Mr. Dusil to do, no doubt, what he did do, which is say, oh, come on, ladies and gentlemen, you've heard all this stuff from the judge. But
and where does he say that? So, whereabouts do we turn to in order to get that?
No, as I say, I don't have the transcript, of course, of the closing speeches. I do have I've got the half-time submissions, and I've got what he said in the Court of Appeal.
Yeah.
So it's clear that was the case that was being run. I've also got there are some references to where he explains that to the judge, what his case was, i.e. no agreement.
But you're not putting it as high as saying that we should infer from the verdict that the jury rejected her evidence that she was coerced in some way?
No. They may well have accepted parts of that and just said, well, so what? I think that covers everything on that discrete issue. Thank you, my lord. My lady. I didn't feel it.
My lord, my lady, 5 points to make in reply just on this point.
Yes.
The first is this, assuming from the indications that my lords have given in relation to the submissions you've invited, that you are with me on the question of whether there's been a misdirection of law, both by the trial judge and by the Court of Appeal.
But we're inviting you to make that assumption for the moment.
beg your pardon,
We're inviting you to make that assumption.
you're inviting me to make that assumption, and so I make this submission on the basis of that assumption. Then the question is, what does the court do applying Section 13 of the Court of Appeal Act? Because that would mean, if I can ask you to turn to page 1136 of the bundle, the court first considers whether the verdict should be set aside on the grounds that either the conviction is unsafe or satisfactory, it's unreasonable or can't be supported having regard to the evidence, it was a wrong decision or misdirection on any question of law, and in the course of the trial there was a material illegality or irregularity substantially affecting the merits of the case, or the appellant did not receive a fair trial, and in any other case shall dismiss the appeal. And then the proviso, the court may, notwithstanding that it is of the opinion that the point raised in the appeal might be decided in favour of the appellant, dismiss the appeal if the court considers no miscarriage of justice has actually...
I'm sorry, I just haven't got the reference. Paragraph
1136, my lord.
1136.
Section 13.
Yes, thank you, sorry.
Now, we respectfully submit that on that assumption that there was a misdirection of law, that the conviction is unsafe or unsatisfactory.
But that depends on whether there was a case of duress that should have gone to the jury, which is what you're addressing now.
But in any
Because if there wasn't, then it may be the judge gave the wrong reason. But if the judge should have said, well, you may have heard, members of the jury, that duress can sometimes be a defence to
Yes.
a criminal charge, but in this case I have to direct you that it isn't.
well, the first
Then
point,
we get to the same place, don't we?
the first point I'd make is this, my lord, that the misdirection of law so fundamentally affected the trial and the process of the trial, because it meant that no consideration was ever given to what matters would need to be addressed for the defence to be properly put to the jury, that one shouldn't get to the question at all of whether on the evidence, particularly the evidence of the caution statement.
The misdirection came at the very end of the trial when all the evidence had been given. There was nothing the judge could have done.
I accept that, but had the judge, and I made this submission earlier, and I don't want to take up my Lord's time by repeating it very briefly. Had the judge correctly addressed herself on the law, then that would have had an impact on the outcome of the case, because it would have been open to the judge, and indeed my submission is it would have been incumbent on the judge to invite the defence to then consider, in the light of her ruling on the law, whether that meant the appellant wished to reconsider her decision whether to give evidence or not. And because of the ruling that was given, that consideration was never given, that opportunity was never given, as a result of which there was never a proper case of duress put in the trial. And now that this board, I assume, has accepted that that was a misdirection of law, the only proper approach is for the matter to go back for that opportunity to be given. And my lord, there was a case that was referred to below. I haven't got it, it's not in the bundles before you, but I will make copies of it available, called Queen against Badjan, which is, I'll give you the citation, 1966, 50 Criminal Appeal Reports, 141, for the proposition that where a defence has not been left to the jury at all, it would be wrong to apply the proviso. The point being, my lord, that the fact that the defence was simply not conceived of as being available meant that the whole trial was affected by that error. So that's the first point we make, that it doesn't matter in any event what evidence there was, given there was sufficient evidence at least for the issue of law to fall to be considered, and that issue of law was decided incorrectly. The second question is whether there is indeed sufficient evidence, and my learned friend has has been addressing you on this question of proximity, and he took you to Hassan, and his submission is this, that there must be a risk of death either to the individual or their family that is imminent and immediate for the defence to be available at all, and he relies upon what Lord Bingham said in Hassan at paragraph 28. And just, if I may take you back to what is said there, it's page 277, 9 to 280. And my submission is this. What Lord Bingham is saying in paragraph 28 is not that this is a hard test, that is to say, unless it can be shown that the evidence was, that the risk was immediate and imminent, the defence doesn't arise. What he was saying was that it was a relevant factor for the jury to take into account. So the submission that was made was that it is a hard test, and my submission is that it's only a relevant factor. And while I accept that the jury would have been properly directed had the judge directed them to consider the immediacy and the imminence of the threat, as Lord Bingham indicates at paragraph 28, it's only a relevant factor for the jury to have considered. My point remains that there was evidence from which the jury could properly conclude that the prosecution had failed to show to the criminal standard that there was evasive action that no reasonable person in the same situation would not have failed to take. And that evidence is that the thing speaks for itself. The defendant is accused of conspiring to murder a witness. It can therefore be concluded that a jury could properly have reached the conclusion that the appellant had a reasonable fear that even if she had gone to the police, even if she had been put into the witness protection programme, the same fate awaited her. And as to the imminence and the immediacy of the risk, while that would be a relevant factor, if the jury had decided that there was no evasive action that could be taken, because eventually the appellant would have been murdered, it would have been open to, it is open to them in those circumstances still to allow the defence to find that the defence is made out. So imminence and immediacy is a relevant factor, but it does not it is not determinative in and of itself. It's not a hard test. So it's not listed as one of the factors in paragraphs 21, 1 through 7 of Lord Bingham's judgment. It is a factor that goes to the question of proximity only. Now, my lords, my lady, there is one finding that was made by the Court of Appeal, which is particularly important in this context, because as my Lord Stevens made clear, and as my learned friend made clear, the real risk with duress is that it becomes a means by which terrorists and gangsters can, by proxy, arrange for their nefarious activities to be carried out without risk to them or to the person who carries them out. And for that reason, one of the factors that is relevant in set out in Mr. Bingham's judgment, paragraph 21, is whether a person has voluntarily placed themselves in the situation that they have laid themselves open to. So if you turn to page 2776, D, the seventh of the factors, the defendant may not rely on duress to which he's voluntarily laid himself open. The scope of this limitation raises the most significant issue on this part of this appeal, and I must address it. And then he referred to Lord Morris's speech in DPP and Lynch at paragraph 26 of his judgment, page 2778. Who had emphasised that duress must never be allowed to be the easy answer of those who can devise no other explanation of their conduct, nor of those who readily could have avoided the dominance of threats, nor of those who allow themselves to be at the disposal and under the sway of some gangster tyrant. Now, it was raised by the prosecution before the Court of Appeal that that was a factor that the appellant would be unable to establish. But the Court of Appeal rejected that submission, and my lords will see that if I can ask you to turn to page 988 of the bundle. And you'll see at paragraph 63, where they said this: the final point for consideration is that the defence of duress is not available to persons who commit crimes as a consequence of threats from members of violent gangs which they have voluntarily joined. At paragraph 68 of the judgment, they rejected the prosecution's submission. Page 990, paragraph 68. Whereas I accept the principle in Sharp and the other authorities, I do not find it to be of application to this case. There was no evidence that prior to the incident involving the deceased, Moss was a part of any organisation, or that she was involved with Big Meech and others to the extent contemplated by the authorities. As such, I do not agree with Mr. Lance's submission on this point. Now, I accept, my lords, that that's not an end of the question of whether she could have taken evasive action, but it is of relevance, and it's particularly of relevance to the policy considerations that underpin the approach that Lord Bingham urged should be adopted, in particular in relation to immediacy and imminence of the risk. And it's simply not a policy consideration in this case. It cannot be said, in the light of the Court of Appeal's finding and the fact there's no appeal against that finding, that the appellant did not voluntarily put herself in a position where she was open to threats of this kind. So, my lords, just in summary on the conviction point, firstly, misdirection of law. That means by virtue of section 13, we respectfully submit the conviction should be quashed regardless of the position on the evidence. If you're against me on that, there was sufficient evidence applying the test in Von Stark for a jury, not just from direct evidence, but from inference to conclude that the Crown had failed to make out a positive case to the criminal standard that duress was not available, including in relation to the issue of proximity. And we rely in particular on the Court of Appeal's finding of fact that she did not voluntarily put herself in the position where she laid herself open to those sort of risks. My lady put to my learned friend who accepted that the jury were not directed at all in relation to the relevance of duress. So there has yet to be any finding by a jury on the question of duress, and we respectfully submit, in the light of the assumed conclusion that your lordships will reach, that the only proper approach is to quash the conviction, to put the Crown to their election whether they wish to have a retrial, so these issues can then be properly ventilated and a jury reach a conclusion. Now, my lord, if you're against me on grounds 2 and 3, that's to say, even if you're with me on the question of law, but you conclude that there wasn't sufficient evidence to put to the jury, there still remains the question of what its relevance is to the question of sentence.
Yes.
And I haven't addressed you yet on the sentence point. What I would wish to emphasise is this, that neither, well firstly, that the question of duress falling short of a defence is a mitigating factor. And my lords will have seen that from the judgment in in Hassan. I'll just take my lords to the relevant section in just a moment.
I think we might as well hear
It's page 2777 of Hassan.
the full argument on this.
Paragraph 22 on page 2777 at D. If it appears at trial that a defendant acted in response to a degree of coercion, but in circumstances where the strict requirements of duress were not satisfied, it's always open to the judge to adjust his sentence to reflect his assessment of the defendant's true culpability. Now, my lords, it was raised by counsel for the appellant before the Court of Appeal that the sentence handed down by Bethel J, the 20-year sentence, was too long because, among other reasons, of the duress, the threats that had been made to her. Now, Bethel J found that there were no extenuating circumstances, and the Court of Appeal, notwithstanding the submission made, simply didn't address the question of whether duress was an extenuating circumstance. And we respectfully submit that that failure alone means that the sentence of 35 years would have to be reconsidered. And indeed, bearing in mind the failure of Mrs. Justice Bethel to consider duress, then that would need to be a fresh sentencing exercise, whether that's carried out by the Supreme Court or by the Court of Appeal. And the proper approach that would be taken, should have been taken, and would need to be taken on any resentencing would be to apply the usual test that it's for the Crown not only to prove aggravating circumstances but to disprove mitigating factors to the criminal standard, and that it's for the court to accept any mitigating factors put forward by the defence unless and to the extent there's a Newton hearing at which the court is able to make findings in which those are rejected. Now, there was no such hearing in this case, so on the basis of those basic principles of sentencing, both the sentence of the first instance judge and of the Court of Appeal were flawed, because they should have accepted the evidence of duress on its face, because there was no Newton hearing in which it could be rejected.
Well, the judge obviously had to assess that evidence amongst all the evidence in arriving at sentence, but did she say anything about that aspect at all?
She just said there are no extenuating circumstances. Right. And so, my lords, what we respectfully...
She considered good character and lack of previous convictions, but there were no extenuating circumstances about the commission of the offence.
My lady, yes.
So by implication, she didn't accept that it was an extenuating circumstance.
Well, my lord, of course, by implication, but bearing in mind the basic principles that I just outlined, that it's for the Crown to disprove any extenuating circumstances to the criminal standard, and if there's any question of those being opposed by the Crown, then ordinarily there ought to be some process whereby...
Well, you've had the process. She just had... You say she should have made some findings about it herself as to what she...
Well, no, the process, my lord, would be if the Crown dispute mitigating factors or extenuating factors, it's for the Crown to prove them to the criminal standard, if necessary, by way of a Newton hearing. And
but you don't need a Newton hearing when you've had a trial, Mr. Byrne.
Well, you do, my lord, if the factors that are relevant to the sentencing exercise are not factors that have essentially been found by the jury inferentially from the jury's verdict. Now, I accept...
Well, what you do as the judge, then, is you make your own findings based on the evidence at the trial.
Well, my lord, if there had been explicit findings in which the judge had addressed those questions, had addressed the evidence set out in the caution statement, and had said, well, this is the evidence that's been given, but I reject it for these reasons, then you would have something upon which to go.
But what you say is, having so roundly rejected duress as a defence to the to conviction, we can't be sure that she had in her mind that nonetheless it was a relevant factor as regards sentence. And if we can't be satisfied that she made that admittedly rather subtle distinction in her own mind, then we shouldn't assume that she did.
Yes.
As I understand it, you say there's powerful evidence in the statement that she made that she was under a degree of pressure and threat from people who dealt in pressures and threats and killed. And whereas the strict requirements of duress may not have been present for the purpose of this argument, those pressures were there, and the judge would have had to make some adjustment to the sentence to reflect that.
Yes.
Also potentially taking into account the evidence about the $200,000.
My Lord, that is something that's never been explored.
Well, it's certainly explored because it's in her statement.
But what we do know in relation to the threats is that there was a series of inducements, which may have started out as a combination of bribery plus implied threat, because she would have known these characters, and which, as she took various steps to avoid being in contact with them, when she was in contact with them, became more and more overt, culminating in the threat that took place on the 30th of April, which was the most explicit threat. There's no evidence, in fact, that she was paid, or whether that was part of the final agreement, apart from that one line that my Lady Rose took me to this morning, and that, of course, would need to be explored at sentence. I accept that. But my Lord, for the purposes of this submission, if you're against me on grounds 2 and 3, that's to say, appeal against conviction, in light of Lord Bingham's observations at paragraph 22 of Hassan, it was incumbent on the trial judge and on the Court of Appeal to address its mind to the question of duress as a mitigating factor, and they didn't do so.
Where are the sentencing remarks?
The sentencing remarks by the judge.
637 is the start of the hearing. Tabs 9 above.
Yes, 637. And then Court of Appeals are ground 4, I think it was. Appeal against sentence, page 991. But the key point, paragraph 90 on page 997, where Justice Evans said, "I am firmly of the view that there were no extenuating circumstances." Indeed, he went on to find that there were certain aggravating features which in fact had not been specifically made by the trial judge, but I'm not going to address you on those. The key point is that finding that there were no extenuating circumstances. And the significance of that is that the case law from Larry Jones onwards has made clear that in a jurisdiction where there's no equivalent of minimum terms with a period to be served to reflect deterrence and thereafter detention only on the grounds of dangerousness, the Court of Appeal has adopted a guideline for murder cases of between 30 and 60 years. Although that has been codified into section 291 of the Penal Code, it is still a guideline, and I believe Mr. Pennington Benton agrees with me that that is the approach that the court has taken, at least in Smith and in the present case. Indeed, you can see that if you're still on page 996 of the electronic bundle in the Court of Appeal sentencing judgment, they deal with that at paragraph 87. And so the only way that the court can depart from the guidance of between 30 to 60 years is if there is evidence of extenuating circumstances in relation to the offence. And both Bethel J and the Court of Appeal found that there weren't any. It was because of Bethel J's finding that there were no extenuating circumstances that the Court of Appeal said that she had not been entitled to depart from the 30 to 60 year guideline. We say both of them were wrong because there were extenuating circumstances on our alternative case, namely duress. My Lords, I'm very grateful.
Were submissions made prior to sentencing?
I beg your pardon?
Were submissions made prior to sentencing?
They must have been.
I would assume so. The reason I ask is, what was coercion put forward by her counsel as an extenuating circumstance?
It was before the Court of Appeal. I'll show you that.
Well, I'm really looking at the sentencing remarks
Yes,
prior to
I
that.
will. I'm getting a nod, but for my Lord and my Lady's note, it's paragraph 73 of the Court of Appeal judgment.
I see.
Page 991.
Paragraph 73.
And then in the Supreme Court, it's page 622, line.
6.
Sorry? Yes. Line 27. This is in fact.
Sorry, could you give me
This is actually, sorry,
page?
page 622.
622, sorry.
622, I beg your pardon, my Lord. But you'll see line 27.
So what are we looking at here?
These are actually the submissions made by the Crown in response to the defence, but they're referring to submissions that have been made in writing by the appellants.
So these are the Crown
advocates.
submissions. Now let's just. So where do you want line what? Sorry.
Line 25.
Thank you.
Again, my lady, the Crown submits that this is some hopscotch game that is being played by the convict, and that it was submitted, or was submitted in their sentencing bundle, that at all times the concerned maintained that any role she played was done under duress, and was of the view that she too would be killed. Anyway, so it was raised as an issue.
Yes.
Both before the sentencing judge and before the Court of Appeal. And we respectfully submit that it could not have been dismissed in the circumstances without the court, both at first instance and the Court of Appeal, addressing itself to, firstly, the basic proposition that it's for the prosecution to disprove extenuating circumstances to the criminal standard and to make appropriate findings or to have held a Newton hearing.
Is the Crown what's the Crown saying about it, trying to follow the submission? Is it saying that they are extenuating circumstances?
They avoided that
I think
point.
that
Or are they just saying, well, this is something for you that's been put
I think they were
forward?
probably saying it wasn't extenuating.
They don't actually.
And actually they do.
Okay.
No,
well,
they go on about whether the statement itself was voluntary, but they don't address the coercion point, I don't think.
well, my lords, my lady, all I need
Anyway,
to demonstrate is that it wasn't. Well, there were positive findings made. There were no extenuating circumstances.
so the procedure is it in prior to the sentencing, plea and mitigation by the defence is given before the Crown addresses the court, is that right?
I will have to take instructions on that
Slightly
specific question.
odd, but no, maybe it's not. I mean, I wonder whether
But
there are
what would have-
written
what-
submissions made.
Yes,
Then the Crown addresses the court, and then counsel for the defence orally addresses the court. I wonder if that's the way it goes.
It may be my lord,
Okay.
but I'll have to check.
It'd be just interesting to know what had been said.
But what you won't find, and what with the greatest respect is you would need to find in the judgment of Justice Bethel and in the Court of Appeal's judgment is a reasoned explanation as to why they find, to the criminal standard, that the defence of duress was not made out, or something less than duress.
Yes, the coercion.
And that they were satisfied of that to the criminal standard, and why, and respectfully, I would suggest also why it wasn't necessary to hear further evidence on the point, in particular further evidence from the defendant who had not given evidence at trial.
Presumably maybe I'm wrong about this, but presumably what was in the defendant's statement was never in dispute. I mean, did the Crown ever challenge anything that was said in her statement?
To the extent that it raised the defence, yes. But
yes. But it was never denied, the facts of the threats and so on.
No, well, they had no contrary evidence. The only evidence was her evidence.
So that was, it wasn't really anything for the judge to find on that, was there? I mean, she should have accepted the truth of it.
Yes, well, my lord, I recognise that that's a point in my favour, and
yes.
I accept it gratefully.
Yeah. Okay.
My lords, my lady, I think I've addressed the points that I wish to raise on behalf of the appellant, recognising the difficulty that there may be points that I haven't made, given the approach that my lords, my lady have invited me to take. But if I haven't taken it, it's in our written case.
Thank you, Mr. Bowen. Agreed.
Might we will just hear it now, in case we don't need to have a further hearing at all?
Yeah.
Mr. Pennington-Benton, we'd like to hear you, please, in relation to the relevance of these matters to the sentence.
Sorry, my lord. I'm terribly sorry. Could we have a 5-minute comfort break?
Yes.
If it comes
5 minutes. We'd like to hear you, please, in relation to the relevance of these matters to sentence at this point. We will then adjourn and reflect on matters over the short adjournment.
Over the short adjournment, yes. Well, my lords, my lady, before because Mr. Riley is going to deal with sentence, with your lordship's leave, so before I do that, may I just have leave to make one point in response to the Section 13 argument, Section 12 argument, which is just, it's a short point. My lords, my lady, if we can just turn up again briefly at page 462. So, closing speeches have happened. The judge at line 20 puts the jury out. Anything you would like me to specifically address in summing up? She says. Good character, she says. That's confirmed. And then over the page, your address, and maybe to Johnson, this Officer Johnson, and indeed it was the cross-examination of Johnson in which Defence Counsel put coercion-type questions. And then at line 4, the judge says, now on the law as it stands, because I was researching this, I noted that duress is not a defence for murder or abetment to murder. I would say conspiracy to murder. Would you like to speak with me on that and look at that? And then Mr. Dussel says, well, when I spoke with duress, I was not speaking of it as a defence. So it's plain that his case is, she has opened up the question as to whether duress is available. If that was his case, that was a plain invitation to make that point to the judge. He then explains, no. And at the bottom, page...
Dudley and Stevens was a bit of a off the point because that was necessity.
Necessity case. Well, it's not exactly bang on point, but... But what he does say is that's not what we are talking about. And at line 28, but what I'm dealing with is the ingredients of conspiracy. That's what I'm dealing with, to show there was no pre-election to joining any agreement to murder anyone, our previous position. So that's the extent of it. And, my lady, my lords, once one, that is then the consistent position in the evidence. For example, page 312. Right, yes, 312. Sorry, bear with me just a second to work out. Oh, this is cross-examination of Officer Coakley. Bottom of page 312, line 31. Sir, you were reading the statement criticising the officer for basically reading. So, Mr. Coakley, so my suggestion to you, sir, is based on what you have written, this young lady is showing no apprehensions. You understand what I mean by that? No agreement or no predisposition to have any agreement with Mr. Sweeting Razor. Because what she has done is even gone, based on what you have here, because we are relying on this, by telling O'Neill, the deceased, what they're up to. Isn't that so? That's just an example of that's the point. He's saying through the witnesses, look, there wasn't really an agreement here. That was his case, and there's no reason to suppose, respectfully, that if the defence of duress was said by the judge to be available, that his case would have changed, because he had an opportunity to say it there and then, and he didn't. And in my respectful submission, what's gone on here, accused of speculating, but I think it's a reasonable inference, is if you can't win on duress, in other words, if you are looking at a case where there is coercion that's less than duress, you don't want to run duress. Because if you run duress, the judge is going to be hammering into the jury all the points that I was respectfully submitting a moment ago.
I don't think you could draw that inference. He didn't think it was available on the law, that's what he's saying. So he's either right or wrong about that.
Well, my lord,
if he's wrong, then the question is, would it have made any difference to what the judge should the judge have put it to the jury?
Well, my submission, my lord, is...
And that's the point that we...
It would be the point if that's what he was saying, my lord. But respectfully, my lord, I don't accept... Well, the point I'm trying to make is I don't accept that he does say it's not available on the law. She has said to him, I would say conspiracy to murder, because we all know the decided authorities say duress is not a defence to murder or attempted murder, and she's saying, I would say also to conspiracy. And he says, and then she said, would you like to speak to me about that? And he says, well, it's not my case.
Yeah, so...
It is not saying, I don't think it's available on the law.
You went on and showed where he accepts it, he concedes it's not available in law.
No, he just says...
I've got it here now, but...
No.
463.
Sorry?
463.
463, what? I don't see him accepting that. He just says it's not my case.
No, but if you read a bit further, you'd find it...
He said, so line 9, he says, when I spoke of duress, I was not speaking of it as a defence. I spoke of it as the whole question of this agreement, because she didn't murder, etc.
Yeah, but over the page on 464 at line 5, but you're aware that duress cannot be used as a defence to murder or abetment to murder, etc. Yes, my lady.
That's the Crown Counsel.
Oh, sorry.
So he never accepts that, and indeed the judge says to him, do you want to grapple with me on that? Right. And he says, no. You can't possibly now say, oh, had she have turned around and said to me, well, it is a defence, I'd have run a totally different case.
Well, what do you infer from that? Because maybe counsel misunderstood or failed to take the opportunity to do it, but nonetheless, there was a strong direction to the jury that they must not take into account duress as it was not a defence, and you've accepted that there wasn't a countervailing subtle point to say, but you still should consider the defence that was put forward.
Well, I'm not dealing with sentence. This is the point I'm addressing before I hand over the sentence. The argument, as I understand it, put against me is even if there wasn't enough evidence in the caution statement for the defence of duress to go to the jury, nonetheless, had the judge said, oh, conspiracy is a defence to, duress is a defence to conspiracy, that the appellant would have then run a different case, or may have run a different case. The appellant may well have then said, well, I'll give evidence, actually, and we'll try and get home on duress. So, in other words, your lordships can't dismiss the appeal based on the fact there isn't enough evidence of duress to go to the jury. So what my learned friend is saying, well, that's not enough, because if you accept that the defence of duress was available, then the appellant could have had a second bite at the cherry on that alternative basis. So my response to that is, you were given an opportunity to argue that it is available, and your point was, on the facts, that's not my case. And the only sensible inference to draw from that is because you know that the evidence, without her giving evidence, without her giving oral testimony, the evidence isn't good enough to get home on duress.
Could you just take me to, I'm sorry for taking out of your way, but page 270, which is the statement. I just want to get my mind around exactly what takes place on the Saturday. 270, line 4. And so Big Meech called me. So that appears to be a telephone communication.
Sorry, my lord, may I have a line? Sorry.
Line 4.
Line 4, thank you. Saturday morning, Big Meech called me and told me
he wanted to see me as soon as possible. And they then arranged to meet at her house, but outside the gate.
Yes.
Okay. And she then receives a call from her mother to get the office keys, and Big Meech offers to take her in the car, okay, to the airport. And it's during the course of that journey that she is threatened. He then later devised a plan, line 16, but there's no evidence as to whether that was a face-to-face meeting or whether it was by telephone or what it was.
Exactly, or when it was.
Or when it was. And
all we know is it was after the morning ride.
Yeah.
What we do know from earlier on in the statement is that she says she stopped taking calls to him, but they were texting each other. So we know, I mean, one possibility is that it was text message.
That was after the murder.
Sorry?
No, that was earlier.
Earlier. So, but obviously, I can't invent facts, but I mean, one of the possibilities.
Well, if you're thinking of immediacy of harm for the later meeting, or the later from line 16 to 22.
Yes.
Yeah. There we are.
Not enough. Yes, we say not enough.
So there must have been a further conversation in which this plan about the car and driving him to Yorkshire Street was
Yes.
confirmed.
And I told you.
His reply, hasn't he? I mean,
Sorry.
Sorry, I was just suggesting that maybe your time had already been, and that.
Yeah.
Yes.
I should sit down.
If you're not going to deal with the significance of these matters for sentence, we should hear Mr. Riley in relation to that.
Yes, indeed. Yes, thank you very much.
sorry about
Didn't it go in my book?
Right.
I'm very grateful, my lords, my lady. In relation to sentencing, there are 3 overarching submissions that I intend to make. And the very first point is that the trial judge, Mrs. Justice Bethel, erred in law when she handed down her sentence. And that error of law entitled the Court of Appeal to intervene. And on one view of the Court of Appeal Act, section 13(3), the Court of Appeal was indeed bound to intervene, and I'll take you to that relevant section in due course. In relation to the second point...
Could you just tell us why you say that?
Pardon?
Could you just tell us why you say that?
Of course, if you turn to page 1137... you should have section 13.3
Yes.
on that page, and that section reads, on an appeal against sentence, the court shall, and so in my submission, shall there is mandatory language, and it directs that the Court of Appeal, if it thinks that a different sentence ought to have been passed, quash the sentence passed at the trial and pass such other sentence warranted in law by the verdict, whether more or less severe, in substitution therefore as the court thinks ought to have been passed, and in any other case shall dismiss the appeal. So the reason why I submit that on one view it could be suggested that the Court of Appeal is bound to interfere is simply reliant on the use of the word shall in that first clause.
Right, that's the first point.
That's the first point.
Second point?
The second point is that the Court of Appeal intervened and they substituted a sentence which was within the statutory range set by the Penal Code, taking account all of the relevant factors in the case. And on that basis, it can hardly be said that the sentence substituted represented a sentence that was outside of the ambit of reasonable disagreement. And so the third point I wish to make is that the Court of Appeal is the local senior court. It's very well placed to judge the need for severe punishment, and it's well aware of sentencing practice in its own jurisdiction. My Lord Lloyd Jones, my Lord Stevens, Lady Rose, you recently sat on the board of the case of Miller and the King on appeal from the Court of Appeal of the Bahamas, which was recently handed down last month, where that proposition was made and accepted.
Now, what's said against you, Mr. Riley, is that there was evidence before the court, which was uncontradicted, that there was at the least pressure exerted on the appellant. And it said that the judge and the Court of Appeal both failed to take account of that.
Well, in my submission, I can come to that as a preliminary point before I develop those 3 points that I wish to take you to.
We'd be assisted if you could deal with that particular point, I think.
I'm very grateful, my Lord. In order to answer that particular point, we have to go back to the beginning and understand the case that was presented at trial. And I know this has been raked over before I've come to address you, my Lord, my Lady, but the essential starting point has to be page 516, and in particular lines 20 to 24. And on this page, in these lines, it is reported that the trial judge states, Mr. Ducil has asked me to point out to you, this is at the close of her summation, Mr. Ducil has asked me to point out to you that the caution statement and the interview is the defence's own defence, and they are relying on that is their defence, semicolon, the caution statement. She has to say nothing more. So in my submission, the point arising out of that is that the defendant's case at trial isn't in any particular doubt. Although the caution statement is vague and non-specific in general in a number of respects, the claim that the defendant's case was essentially, yes, I was involved, but I was subject to some form of pressure. That meant I couldn't agree. That meant there was no agreement. And she relied on the evidence of her pre-trial admissions to that effect. Now, my Lord Lloyd Jones states that, well, put it to me, that evidence is uncontroverted at trial. That might, assuming that to be the case, nevertheless, post-conviction, the defendant completely resiles from that account. During the course of sentencing, 2 probation reports are commissioned, and the first one is dated the 30th of August 2018, and then an addendum report is provided for the hearing on the 3rd of October 2018. Now, those reports aren't in the bundle, but the contents of those reports are led during the sentencing hearing through the evidence of the probation officer. So if you turn to page 542, you'll see on this page the appellant changes her story and she alleges that she was innocent. And at lines 10 to 13, she explains that the information against her, namely the information in the caution statement, which she relied upon at trial, was concocted by the police, and she was tortured into rehearsing the same. My lords, my lady, if you turn to page 544, lines 9 to 11, she particularises, generally speaking, the alleged torture, and she says that she was struck in the face and body and called derogatory names. So the simple point that I take from that is that there's a clear shift from the position at trial, yes, I was involved, but only because of some undue pressure or influence, to I'm innocent, that information I gave about being subject to pressure was all made up.
But that evidence must have been accepted in order to convict her, and so therefore the sentencing should have been based upon the evidence that convicted her. The evidence that convicted her was that she was under pressure. It may have been short of duress, but she was under pressure.
And thought that she would die if she didn't go and pick him up. It had waited for 20 minutes for that reason. So surely the judge in the Court of Appeal should have at least addressed that, and if they were going to say that wasn't an extenuating circumstance, explain why.
Well, the point in answer to those queries, my lords, is that the plea in mitigation, which is at pages 606 to 611...
I'm sorry, before turning to that, I'm terribly sorry for interrupting, but the obligation of a trial judge, irrespective of how the case is presented by the prosecution or by the defence, is to find the relevant mitigating and aggravating factors. And so if you're taking us to a part of the transcript where the mitigating factor is excluded by the defence, doesn't prevent the trial judge from taking it into account. Or the obligation to take it into account.
Yes, my lord. The point that was developed on behalf of the appellant was that there should have been some sort of Newton hearing in order to ascertain the particular factual basis on which the trial judge should have proceeded to sentence the defendant. And so the point I'm seeking to make is that...
Well, that's completely misconceived. You've had a trial. The judge has sat there and heard all the evidence. In fact, the only evidence is the statement from Ms. Moss, and there it is, it's not disputed. Then the judge has to sentence on that basis.
Well...
It's as simple as that.
Well, the only possible point I can suggest in answer to that is to direct my lords, my lady, to the plea in mitigation which is entered on the appellant's behalf, which is entirely consistent with the changing narrative presented by the appellant, and that there's a total failure to mention coercion as a mitigating factor at all. And that's seized upon by the trial by the prosecution, and then the change in narrative is commented on by the trial judge herself. So just taking that in order, I've given you, your lordships, my ladyship, the reference to
I do hesitate to interrupt. I'm sorry about this.
Yes.
But isn't it the obligation of the judge to sentence on the basis of the evidence that convicted the person?
Yes, the sentencing exercise needs to be consistent with the facts of the prosecution case, which the jury have accepted.
Does the judge have an obligation to find aggravating and mitigating factors, even if they're not advanced by counsel on behalf of either the prosecution or the defence? Because if not, I've got it wrong for many years, so please tell me.
Well, I think I'm being kicked under the table, so only very gently. But I mean, that was the main point on that preliminary issue. So,
it may be that the judge had her attention diverted from it by the fact that the counsel went off on a wholly different account of mitigation of events that weren't raised at the trial. But anyway, by the time you get to the Court of Appeal, they had the opportunity to put it right.
Well, let me just discuss one point with my learned leader.
Is this a good point?
Well, it's nearly finished, I think.
Right. Well, I think I can fairly assume which way the board is minded to go on this particular point, and I've made submissions in accordance with the relevant points in the bundle, but if that's the position, then so be it. There's nothing further that the Crown can submit on that particular point.
We're grateful to you, Mr. Riley. The hearing this morning has, of course, taken a very unpredictable course.
Yes.
And, we're grateful to you for your submission made in those circumstances. Thank you very much.
I'm grateful, my lords, my lady.
We'll rise now. We'll sit again at 2 o'clock. And we'll take the opportunity to reflect as to where we are in the meantime. Thank you all very much.